Couple issues though as we look at contracts. Private job. There's no written requirement, no contract writing requirement on a private job. The other thing about a private job is terms and conditions on private work can always typically be negotiated. We're talking about somebody other than state of Ohio, municipality, county, etc. Public jobs, however, typically you cannot negotiate the terms of a public improvement project that is competitively bid as between the owner, the public owner, and the prime contractor. And there is always a requirement that that contract be in writing and signed. As a public improvement contractor, when you're working on public work, if you don't have a signed contract with the sponsoring public authority as the prime contractor, you have nothing. If you're out working on public work, direct under a contract with a public owner, and that owner has yet to sign your contract, you are in a world of hurt. So we always tell our public improvement contractors that are bidding direct to a public owner, do not start work based on a notice to proceed. Do not start work based on notice of intent to award. Start work not when you sign the contract and return it to the owner. Start work when the owner gives you the contract that they've signed with the certification of availability of funds. Why have the contract? Serves as a roadmap. Reduces the risk of argument over key terms. What's the schedule? What's the price? What was the terms going to be as it relates to my obligations on warranty? What rights did I have to rely upon the accuracy and completeness of the owner's plans and specifications? Did I assume obligations as it relates to project design? It's going to delineate the rights and responsibilities of the parties. It should exist. In your industry, proceeding with anything other than an agreement in writing presents to you more risk. I've had a lot of people say, I'm better off because I didn't have the contract signed. I've never seen that work to somebody's advantage. Also, I said earlier, incorporating your proposals into the contract. The reasons we want to see them incorporated, taking what the key terms were that were the basis of your fundamental understanding on price, and making sure either that your proposal is incorporated as part of the contract documents and it controls in the event of conflict with any other terms or conditions, or that you make sure that the terms that are in your proposal that are material to you make it into the description of work scope. So I said something there that I want to make sure I clarify. Your proposal, your terms, this is the fundamental basis for my price. My work is going to be performed between the months of June and September. And if it moves, equitable adjustment applies. My work is going to consist of this number of men working no more than straight time during the week, 4 days a week. And if something else has to be done, then there's going to have to be a price adjustment. You want to make sure that those things are clear. So you want to also clearly and promptly reject unacceptable terms, keep facsimile transmittals. This relates to rejection of change orders. I send you a change order that you receive. My change order proposes to pay you $100,000 with no time extension for the added work and schedule delay that you have proposed to me would be $1 million and a 6-month extension. Do you sit on the change order in your office? Do you just return it? What do you do? In any instance where you receive something in writing that is unacceptable, incorrect, you need to correct it, and your record should be clear. We are returning unsigned your proposed change order number 1. The terms and provisions are unacceptable. Our original proposal stands as presented, hugs and kisses. That ought to be in the file. It ought to be sent back contemporaneously. You ought to make sure there's a clear written record. So I'll always see, the hands will go up. What about email? What about email? If your contract says that notice, and in Ohio I mean this, if your contract says that notice shall be sent to Joe Blow by Pony Express, then that's the way it must be sent. If you want to send a copy email as well, great. But whatever the contract says you must do, you must do. I have in here knowing the other party. Know your source of funding. Public jobs, it's easy. If you're the prime contractor, it's easy. If you're not the prime contractor holding the contract, then you better know who you're contracting with. Am I contracting with the prime contractor who's bonded? Who's their surety? Am I contracting with a sub to the prime? Who are they? What's their payment history like? Are they bonded? Know your source of funding. Like I said, for a prime contractor on public work, it's easy. Anytime a public authority signs a contract, if I'm going to get a contract from the city of Cleveland, Cleveland cannot contract with me until they actually sign the contract and certify the availability of funds. They must literally earmark the funds and put them in an account to pay their obligations to me and no more. The funds are there, assuming that the owner honors its obligation and releases them from the public fund when they're due. Private owners, I've said it before, I'll say it again. What does a private developer need in order to begin work on a multi-million-dollar project? Anybody got the answer? Signature? Better than that. I need a contractor that's dumb enough to go out there and start work without knowing exactly where the funds are to pay. Because I don't have to actually show anybody where my funding is unless they ask. So as you get into these things, when you're looking at the contracts upstream, what you need to do is you need to verify, where's my source of funding, Mr. Owner? You want me to sign this contract? We're ready, willing, and able to perform, but I would like to see that you've got appropriate commitments from the bank, that you've got your funding lined up, that you've got your ability to get the TIF bonds or other things that are being contemplated so that a project like this could perform. You will always be at risk. And I say this in terms of that definitively. You will always be at risk if in fact you sit silent when you get something that you disagree with. The reason is because generally human nature tells us that a delayed response typically is a self-serving response. If you took so much opposition to this at the time that you received it, why did you wait 8 months to open your mouth? If you received this and you disagreed so vehemently with the terms, why didn't you return it and reject it? Now, those classic questions that you get always raise, why wouldn't you say something? Why wouldn't you say something if you disagreed? Silence, though, may be deemed acceptance under the law, depending where you're at, but definitely in Ohio. Voice your concerns promptly. If it's unacceptable, say so and say so clearly. We've received your proposed contract form dated blah. Be advised it's unacceptable. It fails to incorporate the terms of our proposal dated whatever it is. We're returning it unsigned. Also, commencement of performance may be deemed acceptance. My subcontract forms that I prepare for our generals, for example, specifically provide. Subcontractor, if you've received our form and you begin shipping, or you receive our form and you begin performing, that shall be deemed acceptance. And no material different term in any of your proposals as a subcontractor that's performing work on our jobs shall be deemed accepted unless and until they're specifically authorized by us in writing. So, depending on the terms of the actual agreement, acceptance may be deemed to exist merely by commencing performance, even though you never signed. The other issue in terms of knowing when to walk away, and Bruce could attest to this, many instances where some of you who have been around for a long time, that have an established bond line, that have the ability to get aggregate bond financing where other people may not, I might be out there and I've got a problem. I can't bond work anymore. I'm hurt. I'm dead in the water. So I go to Bruce. I say, Bruce, you've got this great relationship with your surety. You've got an aggregate limit that will support my operation. I bid this work to Joe Blow, this owner. It's going to be a great job, but I can't bond it. I want you to step in, Bruce, and sign this contract with the owner and subcontract it all to me, and I will pay you a fee for your bonding capacity to stand in my shoes, and we're going to make a bunch of money. And here comes Bruce. He's going to get 60 large to rent his bonding capacity on this job. Next thing you know, I default. I don't perform. I can't perform for the price I put together. He just kind of winked at the bid, took that risk. In that particular instance, He thought he was going to make a little cash on the side for his bonding capacity, but in the end of the day, he's the one that's signatory. It's his bonding company on the hook, and he's sitting there trying to sort everything out. I've seen that happen time and again. Contractual limitations, impacts, these types of things, and I talked about them earlier. In your industry, as a contractor, timeliness of notice, perfection of notice, strict compliance with requirements of the contract documents that obligate an owner to issue a change order or construction change directive in advance. It is horrible to be a contractor in Ohio. If you don't follow the rules of what the contract says, you are at great risk of waiving entitlement. There are instances replete where contractors have done $1 million worth of the extra work. The owner's rep was sitting right there looking in the hole saying, yep, take it out, take it out, take it out. Contractor did it. The job is built. The owner turns around when the contractor submits its billing and says, you owe me for an additional 1 million yards of excavation out of the hole of unsuitable material. The owner turns around and says, no, I don't. My contract says you're supposed to have a change order signed by me before you do it. And you didn't get a contract change order signed by me before you did it. Therefore, you're out of luck. And the courts routinely say, owner wins. Contractor, go home. That's a hard $1 million lump to swallow, but that's what the law is. As recently in the last 2 months, 2 decisions came out of 2 courts. One on one of these school jobs with an Article 8 process where the construction manager was saying, don't worry, we'll work it out in the end. And the contractor said, okay, I'm just going to keep working and we'll work it out in the end. And it was talked about in the meeting minutes and everybody said, oh, what a great thing this is. And in the end of the day, the owner said, what claim? Contractor said, don't you remember? You asked me to do this work. I told you I disagreed. We talked about it. You told me to just get it done. I got it done. It's all beautiful now. Pay me. The owner said no. And the court said, owner doesn't have to pay. The Article 8 process wasn't followed. The claims weren't timely submitted. Scope of indemnity, lower tier claims. You will agree to indemnify, for example, for lower tier lien claims to the extent that you've been paid for that work by the owner and no more. So if your owner is not paying in accordance with the contract and he wants you to indemnify from all liens and claims made for payment by your lower tiers, I will agree to do it, provided, however, that the amount that is being sought by the lower tier is something for which I've already been funded by the owner. There's other things that kick in with indemnity as it relates to what you're agreeing to do for a third party when you're more in the traditional role for an owner coming in, build the suit, design, build, in terms of what's covered under your policies. You may agree to indemnify from and against loss or damage arising from or relating to your work, provided it's covered, personal injury, property damage, sickness, disease, or death. But the interplay between that type of an agreement of indemnity, which is, okay, this is what we need, right? We want personal injury, sickness, disease, or death, or property damage other than the damage to the work itself, and I've got myself where I've got an insured risk. The question is, what is the service you're providing that may trigger the occurrence that gives rise to that claim? People typically blow through these insurance provisions, and if you really looked at what's in the majority of indemnity provisions outside of a traditional standard clause in whether it's the EJCDC documents, the Joint Documents Committee, or an AIA form agreement unmodified, in most instances you're in a world of hurt. On indemnity issues, a couple other things. OSHA fines and assessments. Man, when you agree to start indemnifying people for their OSHA fines and assessments, if you are agreeing to do that for the specific fine that would typically be attributable to arcing off those wires, to the extent that you've done it, fine. But if I'm agreeing to indemnify Bruce as the construction manager or the owner or as the general, and he's had 5 or 6 other instances like this, so he's going to get tagged with a huge penalty as a result of his prior history, I would be foolish to assume the risk of agreeing to indemnify him for anything that relates to that incident or occurrence. Did everybody hear that? Her question is if there's a warranty out on a project, and it's going to be a 2-year warranty following date of final acceptance of the project, do you need the certificate of insurance to be there for a period of time to cover the warranty? In most instances, that's going to be an issue that's governed by the project contract documents. Your insurance requirements in your owner-contractor agreement will say what specifically is required to be provided in insurance certificates as at the time that the project is accepted and closed. In most instances, they will require a current certificate to demonstrate that you've got the coverage. But in most instances, your contract documents don't necessarily require that happen. It would be prudent for somebody that is looking to verify that insurance exists, and if there's a requirement contractually that somebody be named on a policy as an additional insured for a period not to exceed 2 years from the date of substantial completion of the work, if that's your sub that owes it to you, most prudent that you get it from them. There is usually a requirement in most contract documents that following completion of the work that the insurance will be maintained for a minimum time period, whether it's 2 years, 5 years, whatever it may be. And some people will say yes, provided, however, that it's commercially available for a reasonable rate.